Okay, it's live.
Just a couple of minutes so we can start the call.
Yeah, I shared a live streaming link to everyone.
Okay, I think we can go ahead and start. Janetha, I think you are ready, right?
Yes.
Okay. First, let me introduce Janetha Reddy Kancharla garu to the team. Thank you everyone for joining today's immigration call. Janetha Reddy garu Kancharla with us today to discuss latest visa bulletin, the highlights and the questions that you might have. She can answer all those questions. Janetha Reddy garu, a very experienced immigration attorney. She is practicing for last 10-15 years here in her company is in Washington DC, but her services are all over the United States. And she is very professional, very customer focused. For all our immigration needs, you can always reach out her. And I posted her information in the chat also. And our website name is janethalaw.com, janethala.com, and our email ID is janetha@janethalaw.com, and our office number is 703-880-6409. So the information already in the chat, you can note it down. And and one more thing is the questions you can post in the chat so that we can pick up and she can answer one by one. Thank you again for joining. Janetha garu, please you can start now.
Thank you, Ishwar garu, for the introductory note. Thank you, everyone who are in the call, who are participating. I don't want to waste much time, giving, the background about, what it is now, from Thursday till now, when everybody knows what it is. Usually, we get the visa bulletin in the second week of every month, but this time it's delayed when we got it on October 24th in the morning hours. So, it's a good news for a lot of people, and then, some disappointment for some of the categories. But anyway, when we look into, the visa bulletin, there is a, much rapid forward movement that happened. And then, as you all know, when we go a little bit into the day how the visa bulletin published, and then, till end of the day, USCIS haven't confirmed, which category chart we are going to use, whether it's the filing or the final actions. They posted at times that it will be final action dates, but end of the day they confirmed that it is going to be the filing dates. So if you look into, there is a difference between in the final action dates, like huge difference in the EB2 and EB3, at least around 4+ years of forward movement. And they also, left a positive note on the, for the next month's prediction that predicting at least for, there will be a rapid forward movement, in the next bulletin. So let's assume that, hopeful that, how the things, unfold, maybe by mid of October, like, as, if they delay the next bulletin, similar way, how they did it now. So we'll find it out, at least by third week, but if not, at least by second week of November, what the dates are going to be, in the November visa bulletin. So saying that, this is not the first time that they did this, in 2013, once it happened to the Chinese nationals. Similar way, now it happened to us, the Indian nationals, where EB3 date is much more forward than the EB2. And then with that, we could see a lot of inquiries. I guess, it's all over the United States into all immigration offices that, how could, one downgrade to the EB3, and then, which is also known as the refiling of the I140, and then, just try to utilize this, the great opportunity that is in there, because once you do the I140 downgrading, I140, and then, taking the advantage of the filing dates and then do the 485s concurrently. So that gives one, a great flexibility of, changing the employers and then changing the jobs. And, even with the visa requirements also traveling in and out of the country. So, saying that, I would say I'll spend more time answering, all the participants' question than just, going, briefing about what everybody already knows. So I guess, I'm ready for, Q&A. So, let's go ahead.
Sure. Yeah, I think to effectively use everyone's time, we would like all participants to limit all participants to one question. And I think at the end of the day, if we have more time, definitely I think we can give opportunity for others to speak. So with that, I think we can ask viewers to raise the hand, and then we can quickly unmute them so that they can go ahead and ask the question.
Yeah, there is one question in the chat. So there is a couple of questions in the chat. Janetha Garu, are you able to see those questions?
Yes.
Yeah, can you please answer those first, and then?
Yes. So give me 1 second. Yeah, question from Verma. He's saying EB2 priority date is current for me, but I'm with new employer. I140 is from old firm. What are my options? Priority date is 2011. So when you say EB2 priority date 2011, as you see, the priority date for the filing dates is May 15th, 2011 for EB2. So if you are no longer with that employer who filed the I-140 for you, and your new employer who you are with currently didn't even start anything on your labor, and then don't have the I-140, there's not much option for you with your current employer, but you can always go back to your previous employer and ask him whether he will still be able to move forward by signing the 485. So that way you will be eligible for the 485 filings. So make sure that it's not withdrawn and then it's still active. It doesn't hurt you going ahead and having that kind of conversation with your previous employer. Anji Reddy Pasula says, this is Anji. My daughter just completed 21 years last June. Is there any way we can include her to file the 485 for her? So this is, the question as per the CSPA Act. A lot of people are asking. For now, I'll skip this because we are doing more research on those lines. When we go a little bit into the CSPA Act, it was written, a long time ago. Then when we look into the interpretation of it, it definitely says that as long as the visa dates are available. But 6 years ago, the visa bulletin has segregated these categories, like final action dates and then filing dates. So if you interpret that, now we have two charts that are segregated into final action and filing. So if we interpret into visa numbers availability, under both we have. So I think I still will wait on for to give you a definite answer on that. Most of the people are querying on those. So, the legal, the community is kind of, split on that one. So I'll get back to you on that one, Mr. Anji. The question for Amam to everyone says, after downgrading from EB2 to EB3, do we need to be in H1B status for reconversion, upgrading I485 from EB3 to EB2 in case EB2 final action dates become current? Usually most of the attorneys definitely advise maintaining the H1B as a fallback status. So that way, at least it gives you that kind of, cushion to, be inside the country. If something happens to your 485, at least, you can take it forward. It doesn't really affect your stay inside and then work inside the country. So most of the attorneys do recommend, maintaining that H1B as a fallback status. Next question, Pravi. So my priority date is August 2010 EB2 and have I140 approved from previous employer. Changed job recently, new employer filed perm on June 5th, 2020. Do you think perm will be approved by 3 or 4th week of October? Do you think I able to file I140 and 485 in October? Will USCIS honor dates in November if I'm able to file in October due to perm delay? So, as the perm is already there lined up, I guess, every month the dates really fluctuate on the adjudications of the labors. So go ahead and check on the DOL website, what are the processing dates, and then most likely we are seeing at least around 4.5 to 5 months in between the perms that have been filed. So once your perm gets approved, then you will at least have the eligibility to go ahead and do the I-140 premium, but you just have to make sure that those dates are current by then when your perm, the I-140 perm gets approved. So if the dates are current, then you can do your I-140 in premium and then concurrently do your 485. So we just have to wait and see how the November visa bulletin unfolds, because we could see a lot of inquiries from downgrading, especially from EB2 to EB3. So and there's a question from Sandeep Palla. This is Sandeep. So I have approved EB2 I140 with previous employer. Do I need to move to them to file 485 or still apply being under the current employer? You could definitely be with your current employer, continue working. And then if your previous employer agrees on those terms that, if they are willing to, file the 485, give you the 485J to file your 485, which technically means that if they are confirming that they still have that kind of job offer, you could definitely do so. You don't have to join them, but it all depends upon whether the corporation is willing to or not willing to. So it's Tanishka Yella. My question, I have two-part question. I was working, question one is, I was working for employer A with whom I have I-140 EB2, priority date August 2012. I'm now working with employer B and perm is in process. Can I go for EB3 downgrade with employer B without having to wait for perm processing to complete? Unfortunately, Tanishka, without having the perm approval, I mean, that's when the actual date establishes, and then, with the new employer that you have that kind of offer. So without having something materialized on those lines with your current employer, you said employer B, I don't think you will be able to do anything on those lines. You still have to wait for the perm approval. But once the perm is approved and still the dates are current, that's when you can, play around with the porting dates. Shash, this question is from EB2 priority date 2014 from old employer. New employer hasn't filed perm yet. Can I ask old employer to use my old I140 port to EB3? What would I need from old employer and what are the implications of that? Yes, definitely you can reach out to your old employer and then see whether they will be able to take you back on those lines or, willing to, downgrade, your EB2 to EB3, where technically they will be refiling your I140. One thing I just wanted to make sure that everybody understands here, not only from the employee's perspective, but if you look into the employer's perspective, I'll give you a hypothetical scenario. Like let's say in Shash case, if you when you were working with your employer A, your perm approved, your wages were 100K, let's say, assume hypothetically, and then you already moved out of that employment and then came to the employer B. So if you are going back to them, I mean, they can definitely take you back, but they will also need to meet those ability to pay requirements there. So you need to see whether the corporation will be able to do that, from that standpoint of view. And I think they definitely will run through their immigration attorneys to see whether they will be able to, offer you that kind of opportunity. But yes, if they can, definitely you should be able to do that by refiling the I-140 using the same labor and then downgrading it to EB3 and also concurrently filing the I-485. This question is Sandeep Palla again, I guess. EB2 priority date is current for me, but I'm with new employer. I-140 is from old firm. Priority date is 2012. I'm not really sure what you're trying to communicate, Sandeep, but if your question is whether if your current employer didn't do anything, if they haven't filed, perm for you and then didn't port the date, then you will have less opportunities on those lines. So definitely you can reach out to your old employer to see whether they will be able to take you back on those lines. Venu, if we downgrade from EB3 and gets EAD, if we shift to EAD, what will happen to the H-1B status? Do we need to maintain the H-1B status? How frequently EADs must be renewed? After 180 days after you file your 485, definitely you should be able to, have the flexibility to, shift your or move around with the employers. And I think, in your case, as you are downgrading and then file the I-140 and 485 concurrently, you should definitely wait for that EAD card if you wish to, make a move on those lines. And then when you said what happens to the H-1B status, because you are no longer using it, I mean, you started using your EAD, that kind of, goes out. So whenever, if you really want to go back to your H-1B status, you can do so, but do a consular process and then, keep it ready whenever it is in need. And how frequently EAD must be renewed, it depends. Previously, they used to give for 2 years, but, we are hearing that they might do it only for a year. So we just have to wait and see how all these things unfold in the next, coming 5 to 6 months or more. So, Vinay, my priority date is my 2010 December EB2. My filing date is current. Do you recommend me to downgrade to EB3 since EB3 final action date might move faster versus EB2 final action dates may have long wait? So it's really difficult to predict on those lines, how the final action dates are going to go ahead. But as you are already eligible in your given category, I would say just stay put there, don't downgrade it to, EB3. And then, that's what I'm offering my opinion. But definitely you can just, recheck and make that due diligence call, Vinay. Vihan, is it advised to downgrade June 2011? So it's just, I'm assuming when you say June 2011, it's a category, priority EB2 category. So, I would say maybe you can start gathering all the documents, have everything in place, and then, talk to your employer to see, how it plays out, if you really need to downgrade it. But at the same time, if we are getting the visa bulletin on time, like previous months, unlike in the October month, so you should pretty much have that flexibility to judge on those lines. But also make sure that your law firm who your employer is with, they do have that kind of time to file your petition on time, because pretty much the cases are just flooding in, and then going out quickly. The kind of workload is increasing with all of the law firms, and with some of the law firms I'm hearing that they are not even accepting. So make sure that it's not the same case with your employer's attorney. Karthik, what is the prediction for future visa bulletins? I mean, I don't have a prediction, but as there is a positive note, most likely at least the November and December visa bulletins, I'm guessing that will stay positive on those lines, but we never know. So it always depends upon how many numbers are coming from EB2 to EB3. It looks like a lot of guys would really want to take this opportunity, because it happened in 2015. They just kept it open for 3 days and then again went back. And then if you see track back all the way, in 2007 once it happened. So after almost 13 14 years, this is a good opportunity for everybody. So nobody really wants to let it go, but I mean, make your own individual decisions, and then have a discussion with your immigration attorney, and then make sure that you are making those kind of informed decisions, whatever it is, if it is staying put in the same category or downgrading it. Reddy 1234 says, if I140 and 485 are filed concurrently for EB3 downgrade, can we file EAD together as well, or do we need to wait till I140 is approved? You don't have to wait till the I140 is approved, because the dates are current. You can go ahead and file the I140 and 485 concurrently. But other thing that you have to remember is your 485 EAD and advanced parole I140 downgrade will be received, but they won't actually adjudicate on your EAD and advanced parole till the I140 is approved. So that is one thing I would say. This is Anvita. I was with employer X on H1B with I140 approved under EB2 priority date, EB2 priority date 2013. I moved to new employer 6 months ago. New employer did not start my perm yet. Can the new employer file perm I140 and 485 concurrently under EB3 to get EAD? No, it's not possible, because your employer, your current, you mentioned employer Y, they haven't started anything, so there is no possibility on those lines. I read in a blog from other law firm that is possible to file all three together on the same day. Please see the link below. Okay, I'll check that link a little bit later, but if your new employer haven't even did the recruitment efforts and filed the perm, I'm not really sure how it can be done, because at least once your perm is approved, then I140 can be premium processed, and then 485. But I think you should keep a close eye on the same link and then see how it would go. Sasha, what happens if we file multiple 485 applications? one under EB2 for me and my spouse, and my spouse files under EB3 for both of us. I think it is allowed, just like how multiple H1Bs are allowed, you could hold multiple I140s and multiple 485s. But most of the time, people don't want to spend on the second 485. So what they do is they file under one of the category, and then later on, if the other dates become, current, and then, if that date is, under the higher category, like in EB2, then most likely you can use the interfiling technique. But unfortunately, with this interfiling technique, we don't have any direct communication like, form based that we usually do with the immigration. So you just have to, reach out to them and then try to get their attention, saying that, hey, we already have a 485 that was filed under, EB3, and then we have the other category moved forward. Here is the I140 with that, in a different category where the priority date is ahead, and then just try to get their attention to the 485s, including those 485 receipts. But some people just don't want to deal with all of these things. You do have that interfiling option, but it might take time. By then, USCIS response, the dates might retrogress. That is the most, worst fear that everybody has. So I would say, yes, it doesn't really hurt you filing under, the different categories. So you can definitely have the multiple 485s. Okay, this is Sambi. This is Sambi, got promoted to managerial role after I-140 approval. Will I be able to apply for the 485? So, though you got promoted to the managerial role, I'm assuming that in your question, the underlying statement would be that might not be the same position that was offered to you on the perm and I-140. But if the employer is stating that, yes, they do have two positions, one that you are doing currently, one they already offered it to you on the I-140, yes, if your priority date is current, you could definitely go ahead with the 485 filings if the priority date is current. This is Ashwant Reddy Polikunti. Can we have I-140 EB2 still active even if I downgrade to EB3? Yes, you can, but make sure that it is correctly filed. It's not like, how they do amendment, or, if they do amendment, it's already EB2, whatever you have in place will be gone. Make sure, whoever is filing it properly, it is a refiling. So, when they do refiling of the I-140 using your, a copy of the labor, then, you will definitely retain under the both EB2 and EB3. But only thing is making sure that it's correctly done. Vinay, what happens if you lose job with the current employer or leave country after filing AOS and before receiving EAD and advance parole? So, once you file the 485 with the USCIS and leave before EAD and advance parole, most likely your 485 can be considered as abandoned, just like, once you file your H1B and leave the country where the approval comes back without I-94 in a similar situation. So I would say you definitely need to make those plans and then, stay put till you have the EAD and advance parole. Until it's really required, don't travel outside the country once you file AOS till you receive the advance parole. Because the rule also says that before the advance parole approval, if you leave, it it gets denied. Viduli Pal. So how do I know if previous I-140 has not been withdrawn or revoked? I had the approved I-140 for almost 6 years till last year. So, I'm guessing maybe you might have left the company. If you are within the country, maybe you still try to use that one and then actively pursue another perm with your current employer. But, let's say if you already left the country, I think, you have to reach out to the employer to see whether it's withdrawn or revoked. I think, if it's withdrawn or revoked, the chances are a little bit less, on those lines. If it is open, open, most likely you will be able to, if they agree to it, you should be able to do something on those lines. This is Reddy. It says, I got RFE for EB2 I140. What options I have to downgrade to EB3? It depends upon what kind of RFE, whether it's ability to pay or, the educational requirements, whether you met them or not. Let's say if it is the ability to pay, it doesn't really vanish if you try to downgrade. So still the employer needs to meet the ability to pay because the wages remains the same. But if it is related to educational, requirements that, if they are stating that you haven't met the requirements there, then probably downgrading it to EB3 would definitely help you there. Pavan, EB3 employer A, I140 filed by my employer A and was approved on March 2015. It's a little confusing. Okay, it says EB3 employer A, I140 filed by my employer A and was approved on March 15th in EB3 category with the priority date of August 2014. Okay, I moved to company B, new company on 2017. Yet to file the labor at company B. Okay, my question is, now that the dates are current, can I file I485 based on old approved I140? Old I140 from my previous employer is still active in USCIS website, or file 485 together with the new I140 at company B. See, if your employer, your current employer, who is your employer B, haven't done anything on those lines, you really don't know whether the dates are going to be active till that time frame. You clearly mentioned that labor is yet to be filed. Once they file the labor, at least it takes another 4 to 5 months time frame to do that, unless and until there is an audit, get the approval. And then without your previous employer's knowledge or they giving you the I-485J, you cannot unfortunately file the 485. Definitely you have to reach out to your previous employer. And for your other question that you are saying that you could still see that it is active on USCIS website, I really won't suggest you to go ahead and, take it as granted, because sometimes when attorneys send out the withdrawal notices, so, there is not a mandatory requirement that they will update it. So, the file might have already been there for the withdrawal, but the site still shows. So it's always better to check with the employer, what really happened to it, or maybe you can also do through FOIA. I mean, FOIA also works in a similar way, but I think it's your employer who definitely knows that. Maybe try to do through FOIA and then see whether it is still active on the I-140 file. This is Gayu Shiva. Can I file as a dependent on my husband 485 application as a dependent and then later claim myself as a dependent of his EB2? So I'm assuming, Shiva, your question is whether you can file multiple 485s. Yes, that's what that's what your question is. Yes, you can still hold, one 485 in EB2 and another one in EB3. If I haven't clarified your question, maybe try to put it in a different way. I'll try to answer that. Abhinav Kota, my priority date is December 11, EB2. So do you suggest me to downgrade it to EB3? Please advise. Thanks, Abhinay. So you're saying December 2011 EB2. So right now we are at May. So we don't know how it's going to go and play out in the next bulletin. But let's say if we will have the visa bulletin by mid of October, then, based on that, you can make that kind of move. But, either ways, maybe I think you should definitely engage in that conversation with your employer, and then at least try to get, all the supporting documentation, whatever is required. Either way, you'll be ready to, if it is 2 or 3, based on those dates, you'll have, petition going in. So, the next is Kranti Viranki. My wife and I have separate EB2 I140 approved with different priority dates. My wife's priority date is December 2013 and mine is May 2013. Okay, December and May, same year. Based on the speculations that there will be a rapid movement on, final action dates, what would you recommend on who should consider upgrading to EB3? Also, I'd have my birth registered on later date. Should I have to produce affidavits? Okay, for your first question, I would say I think it's better, whoever is having a later date, downgrading it so that way, the EB2 is still kept at the, at the forward date. That's what I would. And speculation about the rapid forward movement, everybody is positive on those lines, but we really never know how they are going to come back and then, announce at what point of time. So, but at least, as they predicted, hopefully it will move forward. And then you said you don't have a birth certificate, so I would say as it is, okay, registered late, so you can still produce that late registered birth certificate. And also I would definitely recommend having 2 affidavits from your parents stating why the registration was late, so giving a reasoning on those lines and then confirming your date of birth. I think you should be fine to move forward. And then you don't need the original affidavits from your parents. If they are making it back home, they can just email you a copy. You can use them for filing. You don't have to produce the original ones. This is, it says I am from, this is the question of I am. My priority date is April 2014 EB2, but my employer was acquired by another employer in June 2020. New employer has not filed H1 and I140 yet. Can the new employer downgrade to EB3 and file I140 and 485 concurrently? Is it a good idea to downgrade to EB3? What I would say is, it all depends upon how the corporation was acquired and how the merger, happened. Based on that successor and interest rule, I would say just try to check whether an amendment was required. If it is required, try to amend the I-140, and then I think you can also concurrently file 485 based on, if you said your priority date is 2014 EB2. So as you don't have that, you will be downgrading, amending, and concurrently filing. But before doing that, I think you have to reach out to the immigration department, what they have to say about that, successor and interest rule, whether an amendment is really required. Again, Kranti Viranki, my wife and I think I might have answered these. Yeah. Kranti, I guess I already answered this question.
Janetha, you don't need to answer repeated questions. You can just choose new ones.
I'm just trying to, read their names. So, that way at least they'll have that, okay, attend the call, she answered my question. Okay, this is from Ganga. My H1B is valid for another, 3 years, priority date 2012. If I downgrade, can I apply for 85 and not EAD? I would say I really don't get the reason why you don't want to do the EAD, because, once you file the 485 along with the EAD and advance parole, it definitely gives you that flexibility, because you don't know whether your current employer, will remain in the similar manner. So I would say, as you're downgrading and planning to file the 485, I would highly recommend doing the EAD and advance parole as well. So there is a definitely benefit for those. Vinay, if I downgrade from EB2 to EB3, would my EB2 I140 will be cancelled? Can I go back to EB2 if necessary? No, it will not be cancelled as long as it's done correctly. It's not amending, they have to refile. So yes, you can hold, if it is approved successfully under the EB3 downgrading, you can keep both EB2 and EB3. Again, this Gayu Shiva, me and my wife has both. I think it's the same question. will it revoke my original I-140 if I claim as a dependent on the downgrading application? Oh, okay, this is what your question is. No, on your I-140, if the dates are current, you can file for your 485, and also, your spouse can be a derivative beneficiary, and then it's other way around for you as well. So it doesn't go away. This is again ready 1, 2, 3. If I start using my EAD and my H1B is inactive, can I go back to H1B with the same or different employer without lottery process? Yes, if you are using your EAD, you can get the H1B done, but for the consular process, it cannot be a change of status because you are not maintaining that kind of status inside the country. Yes, it is, cap exempt. Definitely, if employer is ready and willing to, you can do it for the consular process, go out and come back in. Ganga, my H1B is valid for another 3 years, priority date 2012. If I downgrade, can I just apply 485 and not EAD or AP? Will I be able to apply EAD or AP at a later date? As long as you have, once you get your I-140 in queue, yes, you can definitely do it at a later point of time using the 485 receipt notice. Previously they used to have all the fee inclusive of, the 485 fee is included along with the advance parole and the EAD, but it's not the same anymore starting October 2nd. So I think, yes, you could, opt it out or at later point of time. I think, you can go ahead either, but, I would definitely recommend going ahead with the initial filing itself. This is Vihan, birth certificate in English with recent registration and 5 years old, notarized affidavits from parents be sufficient. I think if it is registered recently and the affidavits are addressing that point, that why those were registered, why your birth was registered late, I think you could still use those notary, in conjunction with this one. But if the affidavits are just fairly stating, your birth, date of birth, I think it's better to use the affidavits. That's what I would recommend. Kushi, I got birth certificate recently from municipal corporation. Is it enough, or do we need to get affidavits signed on bond paper? Second question, do we need to get physicals during? Okay. If birth registration was late, I guess, if that is the case, I would also try to send out the affidavit stating why the registration was late. So, that way it will be covered. And then whether the medicals are required, I am definitely advising my clients to get the medicals done. The reason is sometimes, USCIS for unreasonableness can do anything. So, I'm not taking the chance. But, if the appointments are not available, then you will not have much choice. But, make sure that you are going ahead and then looking into those. Go into uscis.gov and then put your zip code in there and then see, what are the appointment timeframes available. So I would definitely recommend, including it. Of course, down the road, years later, when the final action, dates are current, you will definitely receive an RFE for the medicals, and then they'll ask the 485 at later point of time. But I wouldn't really risk whether, if the medicals are not there, I don't want them to, get it rejected. Anil, I have a date of birth certificate, but it was taken when I was 20-year old, not at the time of birth. Should I submit additional documentation? Yes, you should get the affidavits done to that effect, that, why the birth, was registered late from both of your parents, and then, submit along with the late registered birth certificate. Rashekar Karu. I had my perm alone in EB3 with priority date 2012 with my old employer, and it was in audit for almost 3 years. And perm got approved in 2016. But then I already switched to my current employer and then holding EB2 priority date of April 2015. Will that EB3 perm with a priority date of June 2012 be valid still? I guess as you said it is an audit on perm, unless and until you file that I-140 and work there for the 180 days, you will not be able to get that porting done under the, priority date porting. So I think you're out of luck here, Rashikar. Naveen Manya. I have 2012 September priority date for EB2. If I apply down porting, as you are aware, a lot of people are applying, if EB3 down port, if EB2 moves ahead, can I stop the EB3 process and continue with the EB2? Yes, definitely. I mean, you don't have to stop, let it continue, but you also can go ahead with your existing one, the EB2 procedure as well. So that way, what happens is, if you are downgrading, refiling it, you are trying to get that EB3 category, and putting this priority date to that. So it doesn't really hurt you keeping it open, and then, getting that priority date, maybe, if the dates go back, and similar thing will pop up in another 6 months or 7 months. So at the time you will be all ready with your, if the EB3 is moving ahead. So don't, stop the process. So once the EB2 moves forward, so continue both. That's what I would say, as long as the employer is supportive of that. This is Gajula Madhavi. Hi, while I-140 is pending, can we submit I-485? Yes, as long as your priority dates are current, whatever the category it is. This is RK. I have my H-1B until 2023, but due to passport expiration, my I-94 is expiring in December 2020. What are my options if I won't get my 485 approved by I-94 expiration? So what I would recommend is, you should not wait this long. Go ahead and get your new passport done, and then once you have your new passport, go into the local CBP office, and then show them this is what it is, and get it corrected. So recently we advised a lot of people around the pandemic time frame, where this is what the situation is when the passports were not coming on time. So you should be able to get those kind of corrections from the CBP, and then file it. But you still have, let's say if you are filing right now, your I-94 is still valid till December. So you could file it right now if you don't have time, but make sure you are getting that I-94 date matching with your H-1B date approval, which is 2023. Okay, this is Anand, secret phone. Okay. I worked with employer A, got my labor and I-140 approved, but revoked when I moved to B. Company B, with company B, I have my I-140 approved, and they are not responding to my calls and emails, and I'm in EB2. If company B employer is not ready to downgrade, and employer A is ready to downgrade from EB2 to EB2 and apply 485, can I do that? Can I remove my employer and do it myself without employer, since B is not responding? It's not a good idea to do it all by yourself. You definitely need a 485J. So, without 485J in there, it could, your 485 application will get rejected. I would say, definitely, as your previous I-140 was revoked, I don't see, if you are going there on those lines, I'm not sure whether you will be able to revive it. Chances are very less. I think your best bet is going with, your employer, B, trying to convince him to downgrade it. Maybe you should, just wait for a couple more days and then see maybe employer is answering the questions on the priority basis of the phone call. This is again Gayu Shiva, I think. Okay. Downgrade, and then asking about will it avoid other primary applicants if EB2 process in future can do interfiling? I think I already answered this, Shiva. I think if you can absolutely have both 485s in both, one in EB2 and one in EB3, vice versa. Your spouse can have on the same line, so it doesn't just go away. Lavender G. Okay, G. It says, is it advisable to apply for both EAD and advanced parole along with the new I140 and EB3 category, or just I485 without EAD and AP? What are the advantages and disadvantages of applying and getting EAD and AP along? I would definitely recommend, applying everything together, because, if the situations remain in the similar scenario, and then, let's say if your employer is going out of business, or, no longer have the position, at least you could use that 180-day rule, and then, have that flexibility to move around. So I would always see it as an advantage. I don't think there is any disadvantage to that, because it definitely, you'll have that kind of flexibility. The other question, same with the lavender, with AOS or only AOS without EAD? Can we apply EAD and AP along with EB3 I140 AOS but not use it? But we have more flexibility to switch into EB2 in case if those dates become current. You can apply, but definitely you can still be on the H1B, and then we always advise to maintain the H1Bs for a fallback status. So you don't have to use, but at least you really don't have to deal with this H1B stampings at the consulate, because let's say if the same government comes into, and then if they extend the proclamation and the ban continues, then it will be difficult task for you to go out of the country and then get a H1B stamping. Instead of that, if you apply 485 advanced parole and then EAD together, at least if you are not using your EAD for work, you can still use your H1B for the work, and for your travel purposes you can always use your advanced parole. So that's the advantage I see there. This is RC. Wife currently working on H4 EAD, and my EB2 is current. Do you recommend applying EAD along with 485, or apply only 485 and continue? I would definitely recommend, because this is based on the 485. Just go ahead, file the EAD as well for with the underlying 485. Rehan, thank you. Say Satya B. How long I can stay out of country while 485 is being processed? You cannot leave the country once you file the 485, but you can leave once you have the advanced parole. Once 485 is approved, how long can we stay in India? So once it is approved, you technically have your green card in hand. So, I would say technically, don't stay outside the country more than 6 months, but, you could definitely enter into the United States up until 1 year if you have a strong reason, that might be a strong medical reason why you are delayed, entering at the nearing of that 1 year time frame. And then if you would really like to stay outside the United States, the best option would be just try to apply the re-entry permits. It will be given for 2 to 2.5 years at a time. So, you just have to let them know what, the reasoning behind you going for the re-entry permit. So that way you are just safeguarding your green card, and then not many questions being asked when you are trying to enter into the country that hey, you stayed outside, and then whether do you really have that kind of intention to maintain, or are you abandoning? So you don't have to deal with that. Can we apply for a green card from India? No. Karthik Chandra, I moved from employer A to employer B. Employer A has I-140 withdrawn. Can I ask employer to start I-140 and 485 concurrently? If it is withdrawn, they can try to refile, but I'm not really sure how it's going to work, especially if it is withdrawn, a prompt from the USCIS based on the misrepresentation or the fraud. So, be cautious on those lines, have all the information before you do that. But once it is withdrawn, I think it becomes really a tricky situation to use the old approved labor. Sridhar Motta Koduru. In October, if I downgrade EB3 with I-140 concurrent filing, once I-140 approved, will the EAD be issued based on the filing dates of October? Yes, once your downgrading I-140 gets approved, then the 485, as it's already receipted, so the underlying EADs and advanced paroles will get adjudicated. Shrikant, my EB3 priority date is December 2014. My dates are current. After filing 485, can we travel outside the country? No, unless you have your advance parole. I don't recommend that. Anvita, thank you. After you check the link, can you let me know the response? I'll try to, but I don't want to really validate somebody's link here. So, maybe just try to give us a call, we'll have a consultation set up, you can reach out to us tomorrow. So, send an email to us at janetha@janethala.com. Maybe you can also question in the same link saying, can you explain me how it is possible? So maybe somebody will try to do that. Karthik Chandra, my employer A is ready to process I-140 and 485, but told in 2 months, else they will withdraw. Is it allowed? And I really didn't get your question, Karthik Chandra. So employer A is ready to process I-140 and 485. Maybe if you are not going back to them within the 2 months, they will withdraw. Okay. So I think, you just have to really make sure that what are his terms and things like that, have a, honest communication conversation on that one. And then, you also just don't try to, do the, cat and mouse games there. So what you have to let them know is whether you are truly willing to go back or not. Sometimes employers feel that, if you are thinking from their perspective, if somebody is doing on a similar lines to you, so, what would you do? So I think it's better to have an honest communication on whether you really have that kind of intention to go back to them after 2 months, and then, see how it all, unfolds. And this question is from Kumar. Hi, I have EB2 I140 with the June 2011 priority date with previous and current employer. If my previous employer accepts to downgrade to 3, is there any implications on my current EB2 EAD if it becomes current in the coming months? I don't think so. Definitely that is a good move if your previous employer is trying to, take you back, or, just say that, yes, we'll be able to downgrade for you. And then, it shouldn't really impact, the one another, the EB2 and EB3, because they are in 2 different separate tracks. Other question is, while we apply green card, will there be any issues because of downgrade? I don't think so. There will be any issue as is, they don't question you for why are you downgrading, but they can definitely come back and, RFE you saying that maybe the employer who gave the 485J just to genuinely check, the position, whatever they offered, confirmed through signing the 485J, whether it is still in existence. And then, they might even go further and then see whether the employer has that kind of ability to pay. They cannot just directly question why you are doing it, but there is another way around. So, flooding with RFEs. So they obviously could do that. But as long as employer is willing to, take you back and help you on those lines, I think, it should be fine. Not really those many issues, as long as employer agrees on those terms. This is Ajit Annamaneni. What are the chances the dates will retrogress in the next few months in employment-based category? So I don't know about that, but maybe we have to, cautiously take a close look at and wait patiently till the November bulletin is out in the October month, and then see how it goes. But as per the positive note, the prediction on the visa bulletin itself says rapid forward movement. Hopefully that remains the same, because, a lot of people will be able to, apply. That's a good news for a lot of people, but, I cannot predict how it's going to go. Reddy 123. When I claim my wife with my 485 on EB2 filing date, and then she can file for me on, okay, yes, she definitely, yes, as I said, it's other way around, both can do. You can do for your wife can do for you as long as the dates are current, and then, filing the 485s, and, one on both the petitions, the other one becomes the derivative beneficiaries. This is Amam, I think, yeah, Amam. After downgrading to EB3 and getting the EAD and H1B status active, if we change job for some reason, how are the future process? Okay, so if you downgrade and get an EAD and then an H1B status active, as long as you have a H1B status active, and then, if there is a change in your job, yes, you can go ahead and then amend the H1B petition and then do so. But, whatever is the underlying 485 offer, the I-140 offer that was offered to you by your employer should, that as that is for the future position. So that will remain the same, because after 180 days, if you are trying to use that AC21 flexibility on those lines, you still need to be with the same, employer for 180 days. And then if you do a 485J with a different employer, then you will be, your position should be under the same or similar. So make sure that you are doing it very carefully. This is Suresh. If I downgrade from EB2 to EB3 and apply 485, what happens to my EB2 I140? Okay, downgrade from EB2 to EB3 and apply, what happens to EB2? If it is active, can apply second 485 when EB2 is current? Yes, definitely, absolutely, you can do so. And then if you are not willing to file another 485, there is an option of interfiling. So, which is a little bit of, time consuming process. We don't know how the USCIS reacts to it, but definitely you can do so. Interfiling option is there. And then if you don't want to wait, if you are in fear of, whether the dates, if the dates get retrogressed, what am I doing here? So, if you are able to afford those, that kind of money for filing another 485, I definitely would suggest go ahead and then file it. I don't see a name on this one, but the question says, my EB2 priority date is September 2014. If I downgrade from 2 to 3 and file EB3, I140 and 485, and I have my H1B valid until October 2021. If my EAD processing is still in process, and if I file my H1B extension in May 2021, if by chance my EAD gets approved and a week later my H1 extension gets approved, will both be active, or my EAD will become void as H1B gets activated, or what will be my status? I think as long as you are, maintaining that H1B status and trying to do those H1B extensions on time, I think, your H1B just doesn't go away like that. So just if you use the EAD, then, you are kind of, not using the H1B. But I would definitely, if you wish to be on the H1B, I think you should be fine as long as you are able to do a timely filing on the extensions, because once you file the H1B extension, so you should be able to get the receipt notice. Based on that, you can continue working. But make sure that in between, if there is a gap in between, don't switch to the EAD. That creates more confusion and the case becomes more complicated. Karthik, how can both EB2 and EB3 petitions be active using the same certified perm? If both are valid, literally every backlog applicant, if currently, can apply for 485. See, when you say how can both EB2 and EB3 petitions be active, because let's say if you are with employer A and then, employer A filed under EB2 category, you have that one active, and then you move away to B, and then, their requirements are only for EB3, they file your I-140 under 3. So of course you are having both, if the previous one is not revoked, kept active, it will be. But if it is with same employer, you mean to say, yes, let's say if one filed, a petition when an employee, let's say you joined your employer, and then, the requirements for the sponsoring of that are EB3. And then after, a couple years or so, of course, when you joined your employer, you do meet the EB2 requirements. I'm just hypothetically telling you, trying to explain it to you, Karthik. So, you meet the EB2, but that is not what the requirement is for the position. So, of course, they went ahead and filed you under the EB3. So, when you have a promotion or so, when they have another kind of opportunity available which meets the EB2 and you meet the requirements, yes, they can definitely. From EB3 to EB2, it cannot be done. But if you have an EB2, then definitely you are automatically meeting those EB3 requirements. So I'm not really sure what your thing is, but yes, a person can definitely hold two active I140s at the same time, one for EB2 and one for EB3. I think you should reach out to your employer or your attorney, just try to ask them how it is. The other question is Mohit Arora. Me and my wife both made the cut in October visa bulletin. What would be your recommendation for us? Should we file our individual 485s, or only one of us should file as primary and have spouses as derivative? If we do that, is there a risk for a derivative to lose the priority date? Can derivative switch jobs after 6 months? You don't know what the life is throwing at you in future, because if you both are actively eligible, then I would definitely say go ahead and file your both individual ones, so that way you can save, God forbid in future something or the other happens to, at least one, because in the, day in, day out, we see so many things that, sometimes all of a sudden something happens to someone and then the other one is completely thrown out of the status. So I think I would definitely recommend both of you, moving individually forward. Having your own would always help you. Okay, I think Mohit's question also is, if we do that, is there a risk for derivative to lose primary priority date? No, there is nothing. Can derivative switch jobs also after 6 months? Yes, if one is filing as a derivative beneficiary, as you will be eligible after 6 months, I think the derivative doesn't really have to meet that, 6 months requirement. So it is only for the principal applicant. So let's say if the wife is not eligible for work at all, and then if EAD comes through, then definitely they can go ahead and then, start working. This is Vivek Velayapan. Can my previous employer file I-485 without having to join them until EAD is received? Yes, if he is willing to, sign you for that 485J, definitely you can use that as an opportunity. Go ahead with your 485 filing, and then it, depends upon when you really want to go ahead and join him. But yes, you can also join him once you receive your EAD. The other question is from Suresh. I have my perm and I-140 applied with my old employer with priority date 2011. And the second employer also did perm and I-140 with EB2 by porting priority date from employer 1. Now, when I downgrade to EB3, does it still carry the first employer's priority date? I think priority, if you are with your old employer, after I-140 approved in 180 days, I think you should still be able to port that priority date, to the other filing. Yes, you should be. Since medicals are, this question is from Sam. Since medicals are valid only for 2 years, do we have to do medicals right now along with the 485? I'm recommending yes to my clients, but again, it all depends upon the attorney who is filing your 485. But of course, if you are filing in the filing dates, not the final action dates, yes, definitely down the road when final action dates become current, they would definitely RFE you for that. They want new medicals, and also they'll ask you for 85G at later point of time. So it depends upon the law firm. So who, what their choice is, but I'm definitely recommending my clients to get one.
Janetha, 1 second, Andy. 1 second. The call will be ending another 15 minutes. So it's already been 1.5 hours over, right? So
it's already 1.5 hours. Oh, didn't even realize.
Yeah, please go ahead.
Okay, thanks for reminding me, Ishwar. I mean, I'll answer as much as I can, if I'm not able to, just send out emails to our office, we'll do a consultation basis because we are quite busy there. Okay, Satish Reddy. Can the green card filed under EB1 and H1B visa and doing managerial role? Previously, I had L1 visa with a different company and currently working with H1 as manager role with offsite onshore model in Indian company. I'm not really sure, can the green card be filed under EB1? Yeah, as long as I think, Satish, you meet those requirements, I think you have to run it through the corporation and the corporation attorney, whether you are qualified. Yes, if you are qualified, then I think you should, file for it. But definitely there is some kind of, analysis required on the role, job duties, whether you are meeting the threshold. Okay, Vinay. Once I file EAD and few months down the line, I get the EAD, but if get married after getting the EAD before I receive the actual green card, can I add my spouse to the application if I get married before the GC? You can only once the dates are current. Let's say, your date, once you got married, once the dates are current, you can add your spouse without having the dates current. You cannot, but you have to keep everything ready. If the dates are current, they must pretty much adjudicate your case. So before they adjudicate, as you know, you will be knowing at least a month ahead or 15 days ahead, the next visa bulletin. So once it is current, when you predict that it's going to be, on those lines. So just try keeping all the paperwork ready and send it out on the first day itself, so that way she can be added. What happens if employer denies to downgrade? What can I do? Do employer have any issues in allowing downgrade? See, this question is from Vishal. So I think, a lot of employers are not really on those lines, it's just not blaming them, but you just have to put yourself in their shoes and then see what are the implications are. Then, if they are going to be, flooding with RFEs once you file the downgrades, then, how they will be. I think the employers also should carefully run each and every individual scenario. It's not like one rule fits everybody. So, just run it through. I think employers are trying to do their best to meet these kind of scenarios. But again, there is a priority given, depends upon whether one is really eligible or not, whether they want to really do it or not. They have their own, positives to go ahead with. I think if the employer is not willing to, unfortunately, you don't have much room there, Vishal. Kranti Viranki. My wife and I have two separate I-140s approved with different priority dates. My wife has a priority date of December 2012 and mine May 2013. Could you recommend on who should consider upgrading to EB3? I guess, in this situation, are you asking the downgrade and wrote upgrade? I'm a little confused with your question, Kranti Viranki. So if you have to, downgrade to, EB3, I would say those who are having the later date, that one will be doing. That's what I would recommend. Vivek Velayapan, is there any standard affidavit format requirements to fix any birth certificate spelling discrepancies? I think instead of fixing the spelling discrepancies, you definitely should go ahead and get another affidavit done. Don't take any chance on that. Otherwise, if you are not able to get it, submit it, but it really shouldn't conflict with the actual name. So Mauli, my priority date is August 11th for EB2. Is it okay to downgrade to EB3 now? So when you say August, as we are in May right now, so it's up to you whether you really want to go ahead, have this opportunity and then downgrade it or do it. Because, it's, there's a difference between May and August. What I would recommend is keep an eye on the next bulletin and then see what decision you want to make. Because at least if the bulletin, regularly comes, if the November one will come in, the first, second week of the October, then, you should be able to make that judgment, I guess. This is DA. My priority date is 15th January 2012. And do you suggest to downgrade January 2012? I think yes, because January, now we are in May, so definitely if it is possible, yes, go ahead with that. But again, that is your own individual choice. Naveen, hello, thanks for the session. My question: once we got EAD, how long should I wait to move to a new employer? And do I need to be in same job profile for which I got my perm approved? Yes, I mean, you'll have 180 days to, under the AC21 to move to a different employer. Again, whenever you make a move, previously we never had this 485J form. I mean, when I say previously, long ago, like, 4-5 years ago. So, we used to just do the AC21s, writing, saying all of the descriptions and all. USCIS really made attorney's job easier by, inventing this 485J. So you just put in everything there and then send it out. So whenever you change your employer after 180 days, yes, your profile in the same or similar, that should be maintained based on what the firm was. Is there a chance for USCIS to reject EB2 to EB3 downgrading or 485 or EAD on the grounds of downgrading from higher tier to lower tier? I don't think so. They just blindly can do that, because when the rule allows, they have to accept those petitions. As I mentioned in the initial couple minutes of my session, this happened in 2013, to the Chinese nationals. There was a flood of downgrading at that point of time. When the rule allows, USCIS doesn't really, restrict it. But as I said, they might RFE and to check whether that particular position is really available or not, making sure that it's not a fraud position. SR, my birth certificate doesn't have last name. I has only initial. Will that be okay, or do we need to get affidavit? I think, in this case, you can, do the birth certificate and at least get a couple affidavits, from your parents, and then, if not available, from your maternal or paternal aunts and uncles, so that will help you. And also there are other alternatives to show that initial K is spelled out how, as in your passport, your educational degrees, and then your, if you have a real estate property, your social security, and then, all those things in your H1B, those are all the alternative ways. Govardhan X. This is Govardhan. My I140 is with my previous employer in EB2. My priority date is current if I downgrade to 3. I reached out to my employer and he said he can help me with filing 485. Here are my questions. My question is, what would be the complications we could foresee approving the I140 in EB3 without joining the previous employer? I mean, you don't really have to join as per the rule, as long as the position is available. He's able to, offer you and take you back. I think, that should be fine, because always this is a future employment. Green card is a future employment. Then continuing the same question, what all are the things I should make sure with my employer and the attorney I should walk through before filing to make sure there will be no issues while adjudicating I-140s? I think, just don't sit on their nerve every day calling them. Then, just make sure you have one discussion and then see how they are doing it, and then let them do their job, because this is a busy time. They just really get irritated at times if too many times you're calling. But make sure you have that one call, short and crisp, and then know how it is being done. If everything goes well and apply for 85, within how many days we should join the previous employer? So once you have the 485 application in there, you don't have to join till it gets, you have the actual approval, with the same employer. 485 approval. I would definitely, ideal situation would be working for them after the green card at least 6 months, but you might not even, let's say, if you use the AC21 and change the different employers, you might not even have, received the card with the same employer. So it depends on what the terms are with you and your employer. In worst case scenario, what will happen if I could join the previous, couldn't join? once I get the advanced parole, can I use AP to enter into the country along without using EAD and continue? Yes, you could do so. This is Pixel 2 XL. Okay. What are the options if we don't have birth certificate? Affidavits are your alternative options from your parents. And, if you have older siblings, and, that's what you could do. Kushi, does USCIS will keep filing dates as is whole October month? Yes, whatever the visa bulletin that they said, it's valid till October full month, unless and until they come back in between and mess it up. If they mess it up, I think definitely there is going to be a litigation on that one. This
I
is,
think, Janetha,
yes.
I think last 5 questions, so we can answer.
Okay, I'll count on that one. Yes. Reddy's iPhone, hi, date of birth, birthplace on passport and birth certificate is different. How can we handle this? I think you should just submit the affidavits. That's what I would say. Swaroop, my priority date is October 14th on EB2. So if I downgrade from 2 to 3 and get the next bulletin a few days, if I file the 2 becomes current, is it possible to withdraw? Don't withdraw the 3, you should still be able to file under the 2 concurrently. So don't withdraw 3 and then, do 2. So you can have multiple I-140s and 485s. SK, I have my priority date as November 2014. Can I downgrade to EB3? I think when you said November 14, 2014, it is EB. Okay, can I downgrade to 3, and how long will it get to approve the file I-140 and 485? Yes, you can file I-140 and 485 together, as you will not be able to premium process your I-140. And then, of course, you don't even have an advantage there because, once it goes, it's there, I-140 gets receipted for the downgrade 485, EAD and advanced parole. So your EADs will be adjudicated just based on your I-140 approval. So how long you said, I would say 485 approval will take a very long time frame, but I-140 should be anywhere between 6 to 8 months. I think this is my 4th question. Ram, I have ported my EB3 to EB2 and my priority date is 2012 March, EB3 to EB2. I don't have EB2 I-140 copy and my employer not shared this info, but I do have EB3 I-140 receipt with me. Is there any way to get EB2 I-140 copy and proceeding filing EB2 to EB3 downgrade with different lawyer instead of employer's lawyer? I think, I don't know, not sure why they haven't provided you a copy. Sometimes they don't share, but, request them a copy. But if you still have a receipt notice, maybe, just use that and try, doing it. So, if it is, but, if you have a copy, that would, help in a great deal. So, because, USCIS officer will definitely look for that. This is my last question for the session. Anush, what if employer is not ready to downgrade from EB2 to EB3? My priority is to, there's nothing much you could do, Anush. So you definitely should have, employer should agree for that downgrade because definitely whatever the paperwork that they are giving, plays a big role in there. I think Ishwar Garu, I'm done with the 5 questions, I guess, rest of the questions, I think, other guys, I'm sorry if I'm not able to answer your questions. So, you can always reach out to us at janetha@janethalaw.com. Go on to our website, janethalaw.com, and see if you can send us an email. Our paralegals are quite busy at this point of time, but, we'll try to see if we can schedule some appointments for you.
Thank you, Janetha. Thank you for your valuable time because I know you are very busy. Thank you for spending time this afternoon. And all participants, please reach out Janetha Garu for your immigration requirements. She is very helpful. She is very knowledgeable in immigration matters. Her address I already pinged in the chat, so please note it down and try to reach out to her. Thank you so much. Thank you all for joining.
And I really appreciate the organization for giving us such a wonderful opportunity, to reach out to the community and help the community. Thank you.
Thank you so much.
You're welcome.